All right, welcome back, everybody. My name is Stuart Hargreaves. I'm a professor here at CUHK Law, and it's my pleasure to chair the first of what proposes or seems to be an excellent conference. I'm looking forward to hearing everybody speak. So for this first session, we have three wonderful speakers. I will run through their bios briefly and then turn the floor over to them. My understanding is that they each will have 25 minutes to present their work. And then the remainder of the time after all three have gone will be for Q&A. And you can send questions to me through the chat box for me to then relay to them, or you can request that you be unmuted and I can unmute you and you can ask the question directly. All right, so our first speaker is Jiong Ye of National Taiwan University's College of Law. He has been substantially involved in many constitutional, legislative, and regulatory issues in Taiwan. Professor Ye has published extensively in both English and Chinese, covering topics such as constitutional law, environmental law, and administrative law. In addition to in Taiwan, he has held teaching positions in the United States, Canada, and Australia, and he has served in a number of high-level government posts, including as Minister of the Interior and Minister of Education. His most recent publications include The Constitution of Taiwan, a contextual analysis, and Asian Courts in Context. Our second speaker is Ryan Mitchell, a colleague of mine here. He is an assistant professor at CUHK Law. His research focuses on international law, legal history and theory, and Chinese law. His current research situates the origins of modern doctrines of sovereignty in the context of late 19th and early 20th century globalization, and examines the systemic implications of China's increasingly active role in public international law. He's currently revising his PhD thesis as the forthcoming book, Recentering the World, China's Reception and Contention of International Law. Our third speaker will be one of our hosts, Professor Bui Nak Sun, who is also an assistant professor here at CUHK Law, where he teaches and researches on comparative constitutional law and comparative law. His recent work includes the monographs Constitutional Change in the Contemporary Socialist World and Confucian Constitutionalism in East Asia. He was previously a research fellow at the Center for Asian Legal Studies at NUS's Faculty of Law, and he serves as an editor of the Asian Journal of Comparative Law. So with that, I will turn it over to Professor Ye. But again, please remember, you can submit questions to me through the chat box or ask to be unmuted following all three presentations. Thank you very much.
Well, thank you, Stuart. Thank you, Bui and Rayhan for putting this together. And this is provide a wonderful opportunity for us in Asia and beyond to talk about this very timely and also very significant constitutional issue. What I'm going to do is to provide a case that happened in 1999, but kind of look into the context of that and try as much as possible to draw theoretical significance and normative significance out of that. And I hope that will fit in the theme of the conference. In 1999, February the 24th, the Constitutional Court of Taiwan issued an interpretation, constitutional interpretation, making it unconstitutional, the fifth constitutional amendments. And that marked tremendous, significance politically, theoretically, and normatively. Well, on the one hand, the court began to receive some sort of credit claiming as a brave, active, strong, you name it, court. They can even challenge the constitutionality of solving constitutional amendment. So that is one. The other one is more theoretically and more normatively. People begin to recognize here in Taiwan, our constitutional court actually upheld the theme that there are eternal eternity clause in ROC Constitution that was promulgated in China in 1946 and continued to implement in Taiwan since after. So with these two development, you see both the court and the constitutional law, got somehow upgraded. And Taiwan's constitutional court now join a group of constitutional jurisdictions that has ever, have a practice declaring constitutional amendment unconstitutional judicially. Okay, so what can we learn from this? If we don't look into the context of that constitutional revision and also the constitutional revision process and the interaction among general public, Congress, courts, and constitutional revision body, then we are going to miss the point. We are going to put something on the book and begin to highlight that as if theoretically this is such a great theory. And without knowing, there are more variables, contextual, underpinnings in it. So before we draw any significant normative or theoretical implication out of that, we need to actually look into the context. And Taiwan's constitutional development and democratic transition and process of constitutional change actually provide this context for our study. Let me first divide constitutional change patterns in Taiwan. And for you, it could be divided in 4 periods. The first period is a time what I call total and amendability. That is when the Constitution, ROC Constitution, was brought to Taiwan, the government put the whole Constitution as something that you cannot touch. You cannot even talk about amendability. That is, the Constitution is so sacred that it's just a token for showing control to the whole China. So people in Taiwan are not allowed to say, we are going to change the Constitution, revise the Constitution. Not about eternity clause, but the whole Constitution. You are not allowed to say that. If you dare to say, we are going to change the current Constitution, you may be put in jail. That's the first stage. I heard Professor Song was saying something about political unamendability, right? What I'm talking about is not only about one clause, party dictatorship or anything, but the whole Constitution. This is the first stage. The second stage, what I call strongman constitutional revision. That is, Constitution began to be revised, but only for the benefit and pursuant to the will of a strong political man, and that is Chiang Kai-shek. Chiang Kai-shek used political revision process, manipulate at that time monopolistic constitutional revision body, and that is National Assembly, to revise the Constitution for his own political gain, so that he can continue to be the president. There's a clause saying with term limit, only 2 terms. So that Constitution was revised 4 or 5 times by the same agency, that is National Assembly. That's second stage. The third stage was I call democratic constitutional revision. That is to launch for democratic reform constitution began to be revised, one by one target for one political crisis and resolve it, and setting the stage for second reform. So from there, 1991, Taiwan began a process of what I call incremental constitutional reform. Altogether, 7 times. 91, 92, 94, 97, 99, 2000, and the latest one was 2005. In this continuous incremental process, there was one constitutional revision, that is the 5th one, in 1999. That was declared unconstitutional. So this constitutional decision actually was not about one constitutional revision. It's the continuation of constitutional reform, constitutional change that happened in Taiwan. In year 2005, the latest constitutional revision, the constitution is completely overhauled to a new, functionally new constitution, although still remain our state constitution. That is National Assembly, the monopolistic constitutional revision body that exercise its power to revise the constitution for political benefit for so long was finally abolished by general public. So the power to revise the constitution now has turned back to the general public through referendum. So this is the story. And that judicial decision was only targeted at one constitutional revision. And that constitutional revision is the sort of continuous constructivist, effort to do political change and constitutional reform. Okay, then let's talk about that particular one. That is the constitutional interpretation number 499. And this probably is one of the most important cases in Taiwan's constitutional practice. The target was about a reform. That is, how can we gradually downsize and finally abolish National Assembly? So at that time, they tried to eliminate the election to National Assembly members in the end, so that they kind of have some sort of interim and sort of provisional measures to extend the term of National Assembly member for some time in order to phase out the next election. That's what they did. And it's through partisan negotiation and also passed by the National Assembly. But the backdrop was a presidential election that began in 1996, 3 years before that time. So there was a second direct presidential election going on, very, very tense competition among political parties. So when they resolute their kind of constitutional revision, as if it is just part of the ongoing and continuous constitutional reform for more public representation in Taiwan, the tickets, presidential tickets, they condemned that because the general public was very unsatisfied with the result, because they extend the term of the National Assembly through a continuous process of constitutional revision has been very, very distrusted by the general public. Because they were from China and continue to exercise their sovereign power, they had taken away sovereign power of constitutional revision for so long, and now they extend their term. So there was public outcry out of that. although it was agreed by major political parties, but a presidential ticket, they turned their position and began to condemn National Assembly, saying that this is outrageous. And the main political party, that is KMT party, they even expelled the Speaker of the National Assembly. They had party discipline against this in order to save the election. So there was public sentiment against the National Assembly, resulting in the petition to the Constitutional Court. Once again, Taiwan's Constitutional Court has to deal with this issue. Political party, across political party line, they argue that this is unconstitutional. It infringes upon people's sovereign power. So the Constitutional Court needs to react to that in a timely manner. The court could actually resort to political question doctrine by saying that this is something we are not going to do. The court could also say this is just a sort of congressional process. And in the previous constitutional interpretation, the court respect the organic rules and the procedural rules of the Congress, saying that we need to respect the autonomy of the Congress. The court could easily follow this pattern and dismiss the case, respecting the political, means of reform. But because of the public outcry, because of the kind of general dissatisfaction against National Assembly, the court chose to take a hard look and come up with very, very harsh normative and theoretical standard, applied to the case. So procedurally, the court found that the process was, grossly flawed. So the court condemned the process and argued against the procedural integrity of the constitutional revision. More profoundly, substantively, the court began for the first time to upheld the eternity clause of ROC Constitution. The court says some constitutional provisions are integral to the essential nature of the Constitution and underpin the constitutional normative order in such provision, that if such provisions are open to change through constitutional amendment, adoption of such constitutional amendment will bring down the constitutional normative order in its entirety. So the court continued to name some of the eternity clause, including Article 1, Principle of Democratic Republic, Article 2, Principle of Public Sovereignty, and Chapter 2, there's the protection of various human rights and separation of powers. A large proportion of provision was listed as clause of eternity. This is very, very strong and doctrinal and normative move by the court. Very, very unusual. Very, very unusual. Considering the ROC Constitution is perceived by people as imposed constitution. And they say these are eternal. You cannot change a bit. But there must be, under unusual circumstances, the court will come out and say this. Then the court began to review two substantive issues. One is about proportional appointment. In order to reform National Assembly, they design a process to have a soft landing. They design to have a proportional representation related to congressional election, so that there will be no election for the National Assembly. The court you cannot have, proportional appointment by the congressional, election. This is one. Number two, in terms of term extension, this is a necessary measure considered by the reformers. They say, no, you cannot extend even 1 day because you have a contract with the general public. By doing that, you are taking away people's sovereign power. So very, very harsh, very, very doctrinal. Normatively, extremely strong in comparison with other decisions that we see, that we observe in Taiwan. Because our view about Taiwan's constitutional court has been dialogic, very sort of cautious, responding to social needs. In the following discussion, I'm going to resolve this paradox by saying that, yes, Taiwan's constitutional court, and that for that decision was a political court, was politicized, just like in many ancient jurisdictions, constitutional court become politicized, just like the politics has been undergoing the process of judicialization. But the constitutional court has been gradually politicized. In Indonesian constitutional court, Thai constitutional court, Mongolian constitutional court, and including Taiwan's constitutional court. Maybe we can also mention Korean constitutional court. Now, Korean constitutional court can dissolve political party, and also impeachment to the president can be decided by the constitutional court. The same in Taiwan. So, is that good or bad? What kind of significance can we draw from this experience? Number one, I need to say that the context is an ongoing struggle to revise the Constitution and do a democratic reform for better public representation in the parliament and also the presidency. Through constitutional reform, although it's sort of incremental, but gradually people gain their power by securing the vote to the president, direct vote, and by securing their rights to vote for their representatives, which otherwise was completely taken away by the nationalist government when they moved to Taiwan. This continuing effort and struggle was a combination of public mobilization, party negotiation, and also court decision. Like, for example, in 1992, Taiwan people got the first time to elect their parliamentarians. That was the first time. How that happened? There was a court decision. JY interpretation number 261, combined with President Li Denghui, what we call Mr. Democracy. He received the representative of the student chanting for reform in front of Chiang Kai-shek Monument. Very similar to something happening in other parts of the world, but ending in a genuine reform. So that reform has been very, very critical for Taiwan's democratization and change. And the fifth constitution was only part of that. When it was declared unconstitutional, the court was retaliated. The pension of the grand justices with academic background. Like me, if I join the court as a grand justice, my pension will be taken away. And the retaliation is exactly about that. So the court got retaliated in the next round of constitutional revision when the National Assembly was not abolished. So it's a continuous struggle. We can only see that in this. The court chose to look at that particular reform in order to simplify the issue, in order to move forward for the total abolishment of the National Assembly in the end. So we can't see that from that particular period. We will see what happened in the end. That is what happened in year 2005. Number two, there were direct presidential elections. In Taiwan, we directly elect our president, and that happened every 4 years since 1994 and since 1996. And now there has been 3 regime changes from KMT to DPP, from DPP to KMT, now back to DPP. Lots of regime change, and people are used to that. So it becomes a very credible, election and to resolve political allocation of political power. That decision and that revision was exactly amidst the presidential election. The president, a presidential tickets, while campaign for their presidency, they refer to this reform. They will say they respect general people's power because there were term extension and authorized the term extension. They knew that this is part of the reform. So by doing that, it actually sort of increased their legitimacy to reform afterwards. So that was part of the process for the total resolution of the constitutional bad design, that is National Assembly. They monopolized the constitutional revision power for such a long time, although they have been doing something instrumental to Taiwan's democratization. Then lastly, let me mention about the nature of the court before I talk about my thesis. That is what I call civil constitutionalism. The court in Taiwan used to be just a rubber stamp to the strong man, to the authoritarian party, to Chiang Kai-shek. But gradually, when the court dealt with the aging representatives who were able to continue to exercise their power, although they were elected in China, and they continue to exercise their power for more than 30 years without re-election. That was because they rendered a decision in the very beginning, interpretation number 31, saying that you should continue to exercise their authority. So they did something wrong in the very beginning. So they paid back. They paid back in the 90s by saying that, no, we used to say that, but now it's different. So you need to step down by the end of next year, allowing for a new election. So the court sort of changed their position, and it was perceived by general public as a genuine move. And there was political dialogue. The court come out and solve everybody's headache by saying that I come out and shoulder all of this. Let's move on and we elect our new parliament. So that was a very, very big move, changing the credibility of the court. Gradually, court began to come up and step into some areas which was considered as very, very political charged. But the court has been very, very careful and prudent, cautious. The court adopted what I call a cautious measure. They've always put that in dialogue. If the political sectors are in agreement. Then the court will come out and providing procedural framework and also theoretical background for them to move on. But they will say you political actors should resolve the issue by yourself. But here are guidelines, here are political frameworks. And this has been pattern of judicial review, particularly when they put up some sort of deadline for the compliance. They are very skillful in doing that. When they make a change normatively, declaring statute or policy unconstitutional, they set up some time for the political sector to comply, including the most recent decision about same-sex marriage. There's the first decision in Taiwan's Constitutional Court legalized same-sex marriage. But the court set up 2 years for the political sector to come up with the law and come up with the decision to implement that, resulting in a very good reaction. That is, the political sector did honor the time. Before 1 week, the Congress passed the law, although there was lots of debate, lots of negotiations by the society. So the Constitutional Court has been dialogically enter into the dialogue with the society. It's not a vanguard court. So court is part of the political process. I like Martin Shapiro's thesis in Court, that book, saying that court actually is part of the political process. So there's nothing wrong that court began to deal with politically charged issues, and court exercise political strategy to deal with the divided society, and also part of the political reform. In the end, I will argue that court has entered into an enterprise, a constitutional engineering, moving Taiwan from authoritarian rule without popular representation to a full democracy, embracing rule of law, build up liberal constitutionalism. Court play a part in this enterprise. Court is only trying to honor general public. There is a theme that I would like to say in Taiwan. Also, Taiwan has been rather successful in this democratic transition. The Constitution is revised. The government is more accountable. The Congress is more representative. The court is more credible. But there was no crisis of new democracy. As Paul Broker was saying, against the backdrop of Central and Middle Europe. The civil society are still very watchful, very engaged, sometimes very critical here in Taiwan regarding who is running the country, who is in power. So the agenda actually is not set by the court. And I can even argue it's not set by political party or set by political strongmen. We always give credit to the civil society. So beginning from the very beginning, either student, voluntary associations, general public, media. And this is what I call civil constitutionalism. We develop constitutional court, and we develop a theory of constitutionalism. And with that sort of representative, democracy, and also limited direct democracy, Taiwan is a very small island with full democracy. Education level is high. There were no communication problems like in China. So this is a test ground for new constitutionalism. And now Taiwan directly elect their president and also elect their representative through also for public policy, public referendum, and for constitutional revision, they can exercise their final say. And it's very, very difficult. So from 2005 up to now, there were no constitutional revision. But people have been very, very critical about constitutional revision process because while National Assembly was monopolizing this reform, it's elite settlement, what we call elite settlement. General public feel alienated. And now, through a process of reform, now they gain their power back. And if we judge from hindsight, that Fifth Amendment declared unconstitutional by the court actually held the final abolishment of the National Assembly and also in the end giving back the power of constitutional revision to the general public. So it's not going to be ad hoc and manipulated by political party. The Constitutional Court in 1993, 6 years before this 499 decision, rendered a decision saying that when you, National Assembly, convene, you cannot revise the Constitution as you will. You need to publish that in advance. You need to tell the people the Constitution. You cannot simply gather and suddenly come up with constitutional revision. The Constitutional Court warned the National Assembly that. So altogether, I would say Constitutional Court and interpretation number 499 serve as a very important part of the continued effort of constitutional reform, including the fundamental issue that is the process of constitutional revision, back to the hands of the people under public monitoring, openness, and accountable. And this is what I have to say to you. Thank you very much.
Thank you very much, Professor Ye. So we now turn the floor over to my colleague, Ryan Mitchell. Ryan.
Great. Thank you so much to our colleagues that are organizing this event, which I think is off to a fantastic and fascinating start. Thanks as well to Professor Ye for this really stimulating talk, which I especially appreciated because I think there's quite interesting points of overlap with the narrative that I'm going to be discussing in just a minute. Let me just share my screen. Okay. There we go. I'm discussing this topic of unconstitutional constitutional amendments by necessity from a somewhat adjacent or orthogonal perspective because as Son, our colleague, was mentioning at the very beginning in the introduction, we are discussing, in addition to jurisdictions that have these judicialized practices of constitutional interpretation, other jurisdictions, including mainland China, the PRC, which do not have judiciable constitutions. And the PRC is certainly the prime example, I would say, of a major state in the world today that is both engaged in extensive public law development in various facets, but that does not assign the supreme interpretation of public law to any court whatsoever. So the discourse of political constitutionalism in particular is relevant to the PRC example, although at various times there has certainly been a real impact on PRC constitutional practices and discourse from very different jurisdictions where constitutions are indeed interpreted and applied by courts. So that's just by way of a preface. But the sort of narrative regarding this, I think, more fundamental kind of umbrella idea of unamendable constitutional framework for the state is one for which I think you actually do, in the Chinese context, the mainland Chinese context specifically, need to go back quite far. So actually all the way back to the Qing dynasty. The image here being at the very end, after the fall of the Qing dynasty, Sun Yat-sen and Wang Chonghui and some of the other early Kuomintang figures that were involved in trying to create a new Republic of China system in 1912, here being photographed right after the fall of the Qing dynasty. But one premise that has been increasingly common in discussions of Chinese constitutional development over time has been the idea that there is some kind of continuity with ideas or concepts or even institutions and practices stemming from the imperial era. And you do see that especially in more recent publications by mainland constitutional scholars. There is this kind of great interest in what does this sometimes termed pre-modern legacy, sometimes just termed imperial sort of institutional history, 2,000 years of it. What sort of continued impact does that have on today's public law, both in terms of the ideas that are involved in the discourse and also in terms of actual specific structural features of the PRC constitutions as they've evolved over time. So the one main concept that I want to address that has been involved in more recent discourse in particular is this term guoti, which is certainly a term that had a huge amount of baggage attached to it from traditional political cosmology, traditional worldviews of dynastic China. Literally, the best translation of this term, I think, is a state form. And the two characters refer literally to the state and to T, which could be in some context translated as dignity, Timian being like the person's sense of dignity. It could also be translated as structure, literally as body. It sort of shares meanings across a variety of different topics that are rather separate in English, so it's really very hard to translate it accurately. And also in terms of its uses historically, both during the dynastic era and into the 20th century and the present, it has been used in a rather ambiguous way to sort of cover quite a bit of territory. So just to get a bit more specific, the discourse of guoti, when you originally see it in the 1790s and on, which I think is the most relevant period to kind of discuss as a foundation for what comes later. This is a discourse in which you have the Qing emperors, starting with Qianlong and others after him, talking about specific actions, either by their own subjects or by notional foreign groups, unincorporated foreign groups, that are still notionally under the rule of the moral authority of the Qing emperor, making demands or launching initiatives that they regard as inappropriate or as invalid in some way. So for instance, when the Dzungar groups in what is today Xinjiang wanted to meet bilaterally with Emperor Qianlong in order to discuss terms for a treaty, that was regarded as harming guoti because it put this put this subject people's leader on the same level as the emperor. And when the British show up and they start demanding access to the entire internal markets of China, that's also a violation of guoti. And so these are contexts that we might think of as being sort of more foreign policy centric, but that kind of domestic foreign distinction was not really applicable during this period of time. So when state officials under the emperor, located right in the heart of the empire in Beijing, do something that is beyond their scope of authority, that could also be just as easily termed as harming the state form, harming the guoti. So it is a very capacious term, and it was used, it was called upon quite often. Importantly, it could also be used in order to justify flexibility in policymaking. So things that were quite otherwise perhaps difficult to reconcile with the imperial ideology of universal rule. For instance, trying to send expeditions into Myanmar and Vietnam to punish local rulers for disobedience. If those expeditions were defeated and the commanders came back home, in order to not punish them, if the emperor didn't want to punish them, he would say, well, it was not quite what we wanted to see happen, but ultimately you did not harm guoti. So the term was deployed in these contexts in order to justify both labeling certain things as incompatible with the essence of the polity and other things as being perhaps not desirable, but nonetheless not threatening that kind of fundamental, those fundamental characteristics of the state. The term was obviously not under the Qing dynasty itself used in reference to constitutional matters. That, however, came about soon afterwards. So as early as the final years of the Qing, you do see this term guoti being used in Japan. There it had been sort of infused with all of this legal theory that was coming from Imperial Germany. This Japanese term kokutai, which referred to this essence of the state, essential features of the polity, was developed into a contrast with another term, seitai, or in Chinese zhengti, which referred to the form of governance. So in other words, you had this contrast, both of two terms, both of which refer to constitutional features of a state, but one of which is describing only the fundamental constitutional structure, the most unalterable essential features. The other term, zhengti, or form of governance, is referring to the sort of transitory or potentially amendable, potentially changing features of the polity. So this is a very influential sort of binary that you see having huge influence in Japan, of course, where it's really developed into kind of mainstream theory, and especially as Imperial Japan becomes more of this sort of ideologically homogenous state where there's a large degree of ideological control enforced over its own public law community in the early 20th century, as well as just the population in general. This discourse of the kokutai in Japan becomes extremely important. In China, it never quite reaches that extent of becoming the key word that is sort of the label that is attributed to state policy or to the direction of transformation of public law in the country. There's one attempt in that direction, though, that we'll talk about in just a second. So the Qing did promulgate the first written constitutional text in Chinese history, this constitutional outline by imperial order in 1908. And you do see the influence of this idea of the state essence, the unalterable characteristics of the polity already at work in this, this text, which is technically it gives to elected legislators all powers to both draft a full constitution and also to make changes to the constitution. No legislative power is supposed to belong to the emperor in his exclusively, and actually he's not supposed to be able to directly take any legislative action, although his endorsement is required for all legislation to go forth, including constitutional texts being drafted and adopted. So there's this need for compromise between the emperor and the legislators. But at the same time, the actual constitutional outline itself is issued in the voice of the emperor as a sort of partial abdication or as a kind of compromise to society, turning over some amount of the imperial authority. And so in that sense, it could easily be interpreted and was interpreted by conservatives at the time as meaning that the emperor has not actually, the institution of the emperor remains fundamental and cannot be challenged. Of course, historical events ensue. The empire is indeed overthrown. And in 1912, when you get that first constitution of the Republic of China, or the provisional constitution that is drawn up, you get the first reference to sovereignty, right? This term had actually not been used in any legal text in China before this point. And so you get this premise that the sovereignty of the Republic of China belongs to the people. Sovereignty, or 主权, is a very important term at this point. It's used mostly in international law contexts, referring to the state's territorial sovereignty. And it is not really being applied very much, at least in official circles, to domestic public law issues, but among intellectuals, among reformers, and in the nationalist party of Sun Yat-sen, Kuomintang, it is certainly being, there is much more discussion of sovereignty in reference to popular sovereignty as well. So the issue of amendment at this point is something that is attributed to the National Assembly, which is created at this point, and is supposed to be the representative of this sovereignty of the people and having the right to determine in full the scope of whatever full constitution they want to adopt after the provisional constitutional arrangement is terminated. But amendment of the provisional constitution itself was attributed to just the Senate, which was the main legislative, kind of day-to-day legislative body that was created. So there's already this sort of distinction between fundamental transformations of bringing in a new constitutional order versus kind of more minor amendments to the existing system. Of course, this is all just kind of envisioned because the system will collapse quite soon. But one other feature that I think was significant that you saw at this point was this attempt to ensure that amendments would be approved on a regional basis as well. Of course, drawing from the US example in particular, this kind of federalist effort to ensure that all provincial assemblies, as well as Mongolia, Tibet, and Qinghai, which at this point are really only tenuously incorporated into the polity, would be able to approve any future constitutional amendments that would be adopted. So the idea is that there is this kind of sovereignty of the people that is really drawing on this idea of the pouvoir constituant, rather than this Guoti discourse that was quite prominent in Japan, that had been quite influential under the Qing just a few years earlier. But as the Republic is formed, this topic of Guoti is actually not one that is really present in a lot of the discourse of the reformers who really want to be more learning from Western liberal democracies rather than from this kind of imperial German and then Meiji Japanese model. Or looking back to China's own kind of traditional political concepts. So that, though, does not last. There's quickly a shift back in the other direction under Provisional President Yuan Shikai, a former Qing strongman general who was seen as a moderate reformer under the Qing itself, but then in the Republic era stood basically for the principle of extreme executive power and then from 1915, seeking imperial restoration, which he does specifically in reference to this concept of Guoti. So he resurrects Guoti basically in 1915 and after in what he refers to as the Guoti Wanti. So he raises it as the Guoti question, as this sort of topic for public debate and discourse. Of course, the regime of Yuan was not really interested in debate necessarily. It was a very stage-managed process whereby regimes supporting intellectuals and politicians were supposed to sort of issue statements in support of the idea that China's fundamental state form, or Guoti, involved a figure of the emperor. And so Yuan is able to enthrone himself, but not able to prevent his soon after overthrow due to an uprising by people who reject the imperial restoration. Guoti, from this point on, sort of achieves more of the fundamental characteristics of its modern meaning, which is ironically comes to be the idea of a rejection of the imperial tradition, that China is fundamentally a republican or popular state in which the people hold the sovereignty, and that there is no longer any role for the imperial tradition. So that's kind of the most common consensus definition of guoti after Yuan's failed restoration attempt. But you do get interesting sort of derivations and further extrapolations of the concept. So, for instance, former constitutional monarchist Liang Qichao, who was a major legal translator and innovator of legal and political theory during this time, is very critical of Yuan's attempt, but nonetheless, the way that he issues this criticism is by saying, well, it's justified for me to have originally supported constitutional monarchy under the empire and now to oppose it in the republic era, because I oppose any talk about guoti that is any other guoti than the one that's currently in place. In other words, it's not something that should be discussed in terms of a change that is instituted. It's a kind of pre-legal, even maybe pre-political reality. It's the structure of the society determines the basic structure of the state. And so it's simply not something that can be changed through a legislative effort of any kind. So he's really, in a sense, somewhat supporting the importance of the concept, even as he is criticizing Yuan's attempt to use it to enact this kind of backward-looking restoration. So moving forward, guoti itself, this concept sort of falls out of the picture to a certain extent. It's still there, but under the further development of the Republic of China under the Kuomintang, there's efforts at implementing a constitution that tend to be prolonged inevitably. So there are these temporary constitutional provisional arrangements similar to that was adopted in 1912, but a bit more fully fleshed out, all of which sort of empower the Kuomintang party itself to continue being in this very hegemonic role over domestic politics, not necessarily really fully dominant over all aspects. There's lots of factions within the party. By the mid-1930s, the Communist Party is extremely relevant factor as well. There's other minority parties that are still present. And then during the war of resistance against Japan, there's the kind of compelled united front between parties. So even though the functioning of government was very much under the control of the Kuomintang, basically up through the late 1940s, the actual constitutional texts themselves were seen as being in part this very important site for internal kind of inter-party diplomacy and for trying to find a constitutional system that would avert civil war, that would create the possibility for consensus between different parties and factions in a very ideologically diverse country. And this is really manifested especially in the 1946 Constitution itself with this institution of the Jibenguoci, of the fundamental national policies, which are intended during this drafting process after the war, during a brief period of collaboration between the Communist Party and the Kuomintang. They're intended to mark the overlap and consensus between the parties. So in other words, this sort of political settlement between the two quite almost evenly matched warring parties in order to try and find a kind of unity government, a basis for unity government that might last going forward. So in that sense, I think the Jibenguoci, these fundamental national policies, are really quite relevant to this topic, at least in their original context. Of course, they did not succeed, nor did the drafters of the 1946 Constitution succeed in creating this sort of stable system that would avert the Civil War, which began that same year and sort of resumed between the Kuomintang and the Communist Party. Nonetheless, this drafting process in 1946 was certainly quite relevant to this this idea of the fundamental characteristics of the Constitution that are beyond amendment. So what happens in the PRC era? So here is where you see guoti come back, and I'll just give us a sort of broad overview of how there's been this return to this early 20th century concept in the context of the PRC. So Mao actually brought this up before the founding of the PRC. He mentions this Guoti-Zhengti distinction. He says that Guoti stands for the dominance and dictatorship of the proletariat. So in other words, anything that does not concern the dictatorial position of the proletariat is a kind of debatable manner of form of governance. And this is really embodied in his approach to constitutions throughout the Mao era. So you have this succession of constitutional texts, the Common Program, 1949, the 1954 Constitution, 1975, 1978, all of which are basically treated by Mao and the party under Mao as transitory texts that don't really, that ultimately can be replaced at will based on the shifting ideological imperatives coming from the party's central leadership. Guoti has basically been dropped at this point, but you do see it reemerge in the after the 1980s. So after the end of the Cultural Revolution, the end of the Mao era, there's a turn to reform and opening up. But this is combined with these four cardinal principles: upholding the socialist path, upholding people's democratic dictatorship, leadership of the Communist Party, and upholding Mao Zedong thought and Marxism-Leninism. And so even though the 1982 Constitution includes principles of separation of party and state in terms of the structural features of government, you see this huge role for this Guoti concept, the fundamental structure concept, to return and to become a major aspect of constitutional discourse gradually over the next 40 years or so until the present. So the 1982 Constitution gives amendment power to not just the National People's Congress legislature, but to the Standing Committee. It basically turns this into a very smooth, regular feature of constitutional governance, that amendments can be introduced in order to match up with shifting policies coming down from the party center. And this allows this kind of guidance to be undertaken under sort of party direction. Amendments really sort of become this aspect of just state policy. So you see the gradual protection of private economic activity, private property, entering into the constitutional text, sort of actually really belatedly, so more slowly than it's actually being found in more everyday legislation or even everyday practices of government administration. So you get the sense of the constitutional amendments kind of catching up with this general policy of economic privatization, of legalization of state functions, and of the sort of liberalization that you see as a basic feature of the 1982 constitutional framework. And you see that especially in these amendments, 1988 through 2004. And then you see these sort of key features that are regarded as putting the Chinese Constitution in a sort of different category from judiciable constitutions that will be looked at as the supreme sort of authority in public law matters. So for one, non-judiciability is never really called into question. There's one attempt to actually, by the Supreme People's Court, to actually have a constitutional jurisprudence in the Qiuling case in 2001, that they say constitutional rights should actually be enforceable in case law, but then that is later retracted just 7 years later. Other principles that are introduced: benign constitutional violation, or the idea that if you have government policies like these many economic regulations since the 1980s that violate the words of the text and block letter text of the Constitution, but nonetheless reflect its essential features, such as this essential policy of reform and opening up, then those can be considered justified constitutional violations, or even ones that have a beneficial effect. And then there's this argument that the preamble, this argument running very much in the opposite way, that the preamble to the Constitution should control and constrain its future developments or interpretation of it. And the preamble very much focuses on this topic of leadership of the Communist Party. So we see Guoti and Zhengti return in this context, especially in the 21st century, it becomes a much bigger topic in constitutional discourse to define what should be these limits to the liberalization and future amendments that can be included in the 1982 Constitution. And so you see basically a commitment by more traditionalist or regime conservative scholars talking about this principle of people's democratic dictatorship being this guoti, or essence of the state, and other features being more transitory in this sort of subordinate category of just form of governance, zhengti. But you do see quite a bit of discourse where people raise their own ideas about what should we consider the guoti to be? What is the true fundamental nature of the Chinese constitutional order that is beyond amendment? So you have some more liberal scholars, albeit perhaps Burkean liberals like Gao Quanxi, who argue that over time there has been this vesting in organs of the legislature, of the popular sovereignty, so that the real guoti is that of having a legislature that's accountable to the people. So that would mean that the Chinese PRC, a National People's Congress, should be actually in function as well as in name, be the supreme organ of the popular sovereignty. That is, however, a minority view. Much more influential and common are the views of what I think you can fairly describe or put in the category of authoritarian constitutionalists, such as Chen Duanhong, PKU, who argues that the guoti is ultimately primarily about leadership of the Communist Party, perhaps has other content as well, such as socialism, democratic centralism, modernization, protection of basic rights. They're in that fifth rung of that hierarchy. So Article 1 of the 2018 constitutional amendments, there's a modification to the first article of the main text of the Constitution, which is the defining feature of socialism with Chinese characteristics is the leadership of the Communist Party of China. This had been in the preamble, as we mentioned, but it's now migrated in 2018 into the main text, into the first article of the main text. There's the other amendments include the creation of the National Supervision Commission, the renaming of the NPC's Legislative Review Commission to the Constitution and Law Committee, introduction of oaths to the Constitution by all major government employees and officials, the abolition of term limits for the state chairman and vice chairman, and expanding the role of environmental protection in the hierarchy of state policy. Of course, that is sort of bearing the lead a little bit. The abolition of term limits was what drew the most attention, certainly, in these 2018 amendments. But arguably, it's really this change to Article 1 that is the most significant, both ideologically and in terms of practical impact upon constitutional interpretation. This is really firmly asserting the idea that the feature of Communist Party leadership, that nature of that leadership, of course, remaining somewhat unspecified in terms of its details of what it should look like, is unquestionable and is beyond any potential challenge in the future. So I'll close by just mentioning a couple features of this discourse. So this is just a chart showing prevalence in social sciences publications of these terms, guoti, zhengti, this distinction between form of state and more transitory form of governance that might be amendable and transformable. And you see that there's actually a huge pickup in the early years of the 21st century, culminating in about 2012, and then actually declining since then, which is ironic given that we actually see perhaps more of a reflection of these ideas in the constitutional text in 2018, just recently. But these first 10 years here of the 21st century were really the period in which you had debate over the content of the guoti. And arguably, since about 2013, that debate has more or less closed down in terms of the practical consequences and conclusions, which have more or less settled on this idea of Communist Party leadership being the fundamental characteristic. You sort of see that reflected in this data about usage. Okay, and I'll just close by mentioning this week, actually, so Xi Jinping has not actually used this terminology previously at all, I think, but certainly not very much. But this week he actually did invoke this idea of the guoti-zhengti distinction Guoti being referring to the People's Democratic Dictatorship, Zhengti referring to the role of the NPC as the supreme organ of government. And this was in this recently issued speech on what ruling the country according to law means and how it should be interpreted. So I think we might see an increasing uptick in references to these concepts in the future. Okay, so I'll go ahead and wrap it up there. Thanks.
Thanks very much, Ryan. That was fascinating. Next, of course, we have Sun. I'll turn it over to you, Sun.
Okay, so thank you. I'm going to share my slides. So I turn to another socialist country, Vietnam, and again, I will focus on intellectual and public discourse on constitutional, unconstitutional constitution. And similar to the case of China, so Vietnamese constitution did not have a provision about the limit of amendment power, but there are some political limitations outside the scope of the constitution. And this creates the tension and space for the public, for the scholar to debate on unconstitutional, constitutional amendment. So in this, it's quite unusual topic, unusual story in Vietnam. Professor Hoàng Xuân Phú, he is a Vietnamese math scholar. He's not a legal scholar. He's very actively engaged in constitutional debate in Vietnam in 2013. And after the enactment of the constitution, he is very disappointed. And he published a long article criticizing the new constitution as unconstitutional. He said that this constitution is unconstitutional because some subsequent provisions in the constitution violate fundamental principles established in the preceding provisions. So in this presentation, I will explore Professor Hoàng theory of unconstitutional constitution in Vietnam and situate that story within the broader constitutional debate in Vietnam and also in the general scholarship, in comparative scholarship on unconstitutional constitutional amendment and unconstitutional constitution. So basically my argument is that Professor Hoàng theory of unconstitutional constitution in Vietnam is a political critical theory of Vietnam's constitution. His theory is not a judicial doctrine, but is an intellectual interpretation of some provisions in Vietnam's constitution in line with liberal constitutionalism and international law. And he used that interpretation as a criteria to critically evaluate all the provisions in the constitution as unconstitutional. His argument echoed the arguments justifying the doctrine of unconstitutional constitutional amendment and the doctrine of unconstitutional constitution in comparative scholarship. His theory suggests that unconstitutional constitution is not necessarily a judicial doctrine, but it can be a political theory which may inform the public debate on constitutional questions. So this is the basic argument of the presentation. Now I'm going to some more details about this story. So Vietnam, a background about the debate. Vietnam has 5 constitutions, and the last one was adopted in 2013. So basically, at the very beginning, the Vietnamese government intend to amend, not replace the constitution, amend the 1992 constitution. But by the end of the process, they make a new constitution to replace the 1992 constitution. So amendment leads to replacement. So during the amendment process, there were many controversial and fundamental constitutional questions like the leadership of the Communist Party, human rights, land ownership. There are some of the key fundamental debates. And this is the most participatory constitution-making process ever happened in Vietnam. So many people engage in the debate, and there's a huge public debate, social mobilizations, activism surrounding that amendment process. And Professor Hoàng Xuân Phú is one of an active participant in that debate. He's not a scholar. He's not a legal scholar. He's not even not a constitutional law scholar, but he's a math scholar. He got a PhD degree in science in Germany, but he's very active in the debate. Let me explain what this is. Not very. It's quite common in Vietnam for public scholars to engage in public debate issues, not only legal scholars, partially because of the Confucian culture. Because of the Confucian culture, the Vietnamese people, they valued the scholars. Then they expected the scholar to engage in public debate, and not only like purely doing academic work. So because they value scholar, they really appreciate scholars. So in that way, they expected that the scholar should engage in public debate, whether you are a legal scholar or a science physics or. And so that is why in the 2013 debate, there were many non-legal scholars in social science, journalists, activists, literature. They engage in that debate. And Professor Hoàng is one of that scholar. He also a member of the 72 group. 72 group is a group of 72 intellectual scholars. They submit a petition to the Vietnamese government to call for fundamental change to the political system, including freedom of speech, free election, separation of power, creation of a new constitutional court, and creation of a human rights protection institution. And that petition then was signed by more than 10,000 Vietnamese people. And Professor Hoàng is one of the first signature of one of the member of the 72 group. And during this, the constitutional amendment process, he wrote several articles to suggest for amendment. For example, he talked about land ownership, the relationship between the party and the people, the role of the Communist Party confirmed in Article 2 of the Constitution, and change the nation name by removing the term socialist from the nation name, and human rights, a lot of fundamental issues. So after the amendments, he's quite disappointed, and he wrote 4 articles to criticize that constitution. The first article, he said that this is a misamendment, meaning that that amendment did not create a positive change, but create more negative effect, consequence to the Vietnamese political system. The second article, he said that this is not, it's just a draft constitution. It's like we are going to have a new constitution or amend the constitution soon, he said that. And the third article, this is the article he called the new constitution is unconstitutional. The title of the article is called Unconstitutional Constitution. And finally, he wrote a very long article considering the whole process of constitutional amendment and the substantive contents of the amendments, and to end this his constitutional writings. So now I turn to his article on unconstitutional constitutional amendment. I should mention that these writings were published in his personal blog, not in official media because of the censorship. So his theory, there are many things about his theory, but I will focus on 4 questions in his theory. What is an unconstitutional constitution according to his theory? And I give 3 examples in his writing of how he thinks that the constitution are unconstitutional in human rights, land ownership, and popular sovereignty. So what is an unconstitutional constitution according to his theory? According to his theory, Chapter 1 in Vietnam's constitution established principles fundamental to the subsequent provision on rights and state institutions. So subsequent provisions on rights and state institutions can be considered unconstitutional if they violate the constitutional principle in Chapter 1. So he points out 4 such unconstitutional provisions on human rights, citizen military duty, military force, and the land ownership. Now, even within Chapter 1, constitutional provision in Chapter 1 can be unconstitutional if the subsequent provision violate the preceding provisions. In that base, he points out 3 such unconstitutional provisions which established the leadership of the Communist Party, the role of Vietnam Federland Front, and the role of Vietnamese labor union. I don't have time to go into details all of this one, but I will go to 3 provisions. Human rights. He argues that Article 14 in the Constitution recognized human rights according to the Constitution and the law is a violation of Article 2 in the Constitution, which provides that the states protect human rights and citizen rights. Now, the background for this argument is the controversial debate about human rights during the amendment process. The debate focuses very much on how Vietnam should move from communitarian understanding about human rights, from more universal understanding and provisions about human rights. Communitarian understandings and statist understanding try to use law and constitution to limit human rights. Rights can only be recognized if they are provided in the Constitution and the law. And scholars try to advocate for removing the term, the phrase according to the Constitution and the law, by saying that even human rights are universal, natural, internal to human being. It doesn't depend on the state's recognition by the Constitution and the law. Even though you don't recognize, we also have internal, natural human rights. And he also advocates for that one. So Article 3 of the Constitution say nothing about human rights according to Constitution and the law. And Article 3 should be understood in that universal concept. But Article 14, they try to use Constitution and law to limit human rights. And because of this restriction, he believes that Article 4 is actually unconstitutional. Another provision is Article 53 in the Constitution provides for the state ownership of all lands. And he believes that this provision violates the constitutional right to private property established in Article 32 of the same Constitution. Now, again, there's a very, the land ownership was a very controversial topic during the amendment process. In Vietnam, there's no private ownership of land. The state nationalized all lands. And this creates some very controversial and tensions, and people protest the state taking their lands and in the rural areas. And that is, scholars, they believe that the reason for that unrest, social unrest about land issues, is because the state did not recognize their private right to land ownership. So this is why the public advocate for multiple forms of land ownership, including private ownership. But the new constitution did not follow that suggestion. They still established the state ownership of on land. But at the same time, all the provisions in the constitution provide for private property. And he believed that this provision, provision on state ownership of on land is unconstitutional because of this violate another provision on private property. Popular sovereignty is another key issue. He believes that Article 4, which established the leadership of the Communist Party, similar to Article 1 in China Constitution, violates Article 2 in the Constitution, which vests the power to the people. Article 2 said that in Vietnam, every power belongs to the people. Article 2 said that the party is the leadership of the state and the society, the leading force of the state and society. During the amendment process, the Communist Party, the role of the Communist Party in the constitutional system is very strong. It is very controversial debate. Some activists and lawyers, some activists and intellectuals, they advocate for removing Article 4 in the Constitution or deleting the leadership of the Communist Party in the Constitution. That article appears in the Constitution in Vietnam for many decades, and now they want to delete that one to create the foundation for more democratic system. And Professor Huang also wrote several articles to advocate for that deleting of Article 4. And no, by the end of the day, the Constitution still retained that article. And this is why he believed that this Article 4 is unconstitutional, because Article 2 confirms the people is the source of power. And if the people is the source, the author of power, the people have the power to select their leadership, to select their government. So there should not be a constitutional confirming of a leadership of any political force in the Constitution. This is why he believed this article is unconstitutional. So that was some basic arguments in his theory. Now I turn to analyze this theory. The first point is that unamendability is the condition for the debate on unconstitutional constitution in Vietnam. The new constitution is conceived as unconstitutional not because what it changed, but because what it cannot change due to political unamendability. Unamendability can be formal, like constitution established some provision that cannot be amended. Unamendability can be judicial, like courts interpret some provisions, like in India, construct some provision as unconstitutional. But unamendability can also be politically constructed. Vietnamese constitutional amenders, they willing to amend the constitution, reform the constitution, but during the amendment agenda, they establish certain provisions that cannot be amended, including the leadership of the Communist Party, the relationship between fundamental rights and fundamental duties, and the state ownership of on land. So these provisions are unamendable, politically established. So this debates, this political construction of unamendabilities create the tension for the people to discuss, to refer to some other norms in the Constitution to argue that if you don't allow to amend that provision, your Constitution can be unconstitutional. This is the connection between unamendability and unconstitutional constitution. The second point in my analysis is this: there is a connection between constitutionalism and Professor Huang's doctrine of unconstitutional constitution. Professor Huang's, based on the liberal construction of some fundamental provisions of Vietnam's constitution, is the criteria to evaluate all the provisions in the constitution. So consequently, his doctrine is actually that the Vietnamese constitution is unconstitutional because some of its provisions contradict fundamental norms of liberal constitutionalism, like free election, universal human rights, and private property. So in this sense, his theories resonated with arguments justifying unconstitutional constitutional amendment doctrines. Like some core values of liberal constitutionalism are so fundamental that they must be beyond the scope of constitutional amendments. And in his theory, in his paper, he referred to foreign countries a lot, like the US, or he said that now we should open our soul to look at American Constitution and to look at the constitution of powerful countries in order to reform our constitution. So he is actually influenced by a liberal understanding of constitutionalism, and he used that understanding to evaluate the Vietnamese constitution. So there is now the migration of liberal constitutionalism in Vietnam, and that migration create the intellectual condition for the scholar like Professor Huang to argue about the unconstitutionality of the Vietnamese constitution. My third argument is that there is connection between international law and unconstitutional constitution in his theory. Professor Huang's theory of unconstitutional constitution is also based on international law, especially international human rights law. He used international human rights laws to evaluate some provisions in Vietnamese constitution. For example, he referred to the Universal Declaration of Human Rights to advocate for a universal understanding about human rights. And in another argument, when he argues that land ownership provision is unconstitutional, he also referred to a provision in the Universal Declaration of Human Rights on private property. But he did not establish a hierarchy between domestic constitution and subordinate that domestic constitution to international law. His plan is this: he construct some provision in Vietnamese constitution according to international law and use that international interpretation as the framework to evaluate Vietnamese constitution. He did not claim that some provisions in Vietnamese constitution are unconstitutional because they violate international law. But he claims is that some provisions are unconstitutional because they violate the Vietnamese constitutional commitment to comply with international treaties that the country signed. So in this sense, his claims still stick to domestic law, because the Vietnamese constitution also said that the state will committed to comply with international treaties. So if you don't follow global standards of human rights, so you don't comply with the international treaties you already signed. This is his basic argument. So that are my 3 points about his argument and about analytical points about his argument. And finally, I will end this presentation by refer to the connection between his theory and scholarship, comparative scholarship. So in recent years, a scholar also talk about not only unconstitutional constitutional amendment, but also unconstitutional constitution. Richard Elbers, for example, he wrote an articles on different dimensions of the democratic dimensions of unconstitutional constitution, and other scholars also wrote about this about from unconstitutional amendment to unconstitutional constitution for the case of Honduras, and another professor writing about unconstitutional constituent power in a recent collection. So now there's a new development, not only unconstitutional amendment, but also unconstitutional constitution. So how Professor Huang's theory fit with that comparative scholarship? So Professor Huang's discourse of unconstitutional constitution resonates with to some extent with the Honduran cost theory of unconstitutional constitution. He also argues that some parts of the Vietnamese constitution are unconstitutional because they violate, they contradict all the fundamental parts of the same document and also international human rights law. However, his theory is not a judicial doctrine, but a critical theory of Vietnamese constitution. So why does this matter? So when we read this article, his theory, so what can we learn from that one? They are both national and comparative lessons from this story. National lesson. His theories can help us to better understand the sources of constitutional dynamics in Vietnam. It indicates that the dissonance within Vietnamese constitution and between Vietnamese constitution and transnational constitutional law create the space for the dynamic of constitutional discourse in the country. The constitution is very ambiguous, vague, including many vague, ambiguous provision, and this create the space for the public discourse, critical discourse on this document, including the discourse on unconstitutional constitution, as we have just seen. Comparatively, his theory suggests that unconstitutional constitution is not necessarily a judicial doctrine, but it can be a political theory which may inform public discourse of intellectual citizens and legislators and government office. So this is the possible comparative implication of his theory for the scholarship. So I will end the presentation here. Thank you.
Thank you, Sun. All right, so we have, I suppose, roughly 20 minutes for questions. So again, if you want to send questions into me via the chat box, I can then read them out. Alternatively, Rayhan has pointed out to me that you can in fact just unmute yourselves and ask questions directly if you prefer doing it that way. So whichever one is easier for you. If we're waiting for some submissions, I'll turn it over to Rayhan. You had some questions yourself?
Yeah, thank you. Thank you all. They're really fascinating presentations. I learned a lot about all three jurisdictions that I didn't know before, so thanks very much for that. I have, one question for each of you. So I'll just go in order. So first, for Professor Ye, so from reading your own work and of Wenchen Chang and others, I understand that the Taiwanese Constitutional Court is a pretty strategic court, right? It's quite cautious, as you say, in its use of its judicial review power. And I wonder if you think that, you mentioned that kind of politics have been judicialized. I was wondering if you think the judiciary is getting more politicized, in the sense that you mentioned the kind of DPP, KMT divide in Taiwan. Does that translate at all to judicial appointments or the way judges rule? Or is there a way in which the Taiwanese Constitutional Court rules, maybe the civil law system, that insulates it a bit from that? Because what we see, I think, around the world is that as politics becomes more divided, you see that reflected in the court, right? The obvious example is the United States. I mean, now there really are such a thing as a Republican judge or a Democrat judge. And I'm wondering if maybe, even not now, in a few years, we might see something called a KMT judge and a DPP judge. So that's my question for you. For Ryan, this was really fascinating. I'd never heard the term guoti before. Apologies for the pronunciation. And I'm wondering, you kind of alluding to this, and maybe you don't want to say one way or the other, but it seems to me that it's become basically an empty signifier, and that there's no there, right? That it meant something in the Qing dynasty. It perhaps meant something, in the early years of communist China under Mao. But now it seems like the contours of it change basically based on ideological and political direction. And so I wonder whether you think there actually is an identifiable core. And if not, whether you think that just for political reasons, certain aspects of it will always stay, or will stay as far as we can imagine, like the CCP being central or the Marxist-Leninist system. And then my question for Son is, I'm curious about what you think of Professor Huang's arguments. Like, are these arguments that are actually convincing in a Vietnamese context? I have to say, like, reading your paper, like, his arguments sound like a mathematician doing law, right? It's like these two things aren't exactly equal, so therefore one must be wrong. It seems to kind of lack a kind of lawyerly take on how to read a constitution. And if you compare it with the Honduran example, right, what the Dixon, Landau, and Rose Nye say is that the Honduran Supreme Court was not acting in good faith, right? They were kind of referring to international human rights law to actually do something quite contrary to international human rights law, right? Kind of with the term limits in Honduras, and something similar happened in Bolivia. So I don't want to ask you if you think Professor Huang is acting in good faith, but I wonder if you think that the arguments are actually convincing, or whether this is just a strategy to try to reform the Vietnamese system. Obviously it is a strategy, but is it more than that? Is there actually something useful about his theory?
Professor Ye, you want to respond first?
Yes, I think this politicization takes various forms, but I don't mean to emphasize this is a bad idea. I just want to echo Martin Shapiro's idea that constitutional court or court itself is actually also part of the political process. And it really depends on what kind of judicial strategy, what kind of perception that they have, whether they can manage to steer the political tide in a very reasonable way and an acceptable way. But when it comes to political appointment of the grand justices, the role of the political party may emerge, because we tend to think that anyone in power will have the power to appoint grand justices. Yes, it is like that, but it really depends on the institution, the system, how we design a system to avoid that kind of political. So for example, whether it's going to be completely appointed by the same president, or they are going to be staggered. If this is going to be staggered, there is sort of chance of being appointed by the incumbent president may be ad hoc and not that dramatic. But if we allow the president to appoint, say, all or half of the justice at the same time, and that will make this kind of problem even more on surface, okay? And also numbers of the justice or who can decide. Like, for example, there are 5 constitutional courts in Asia. Almost all constitutional courts have 9 justices. And they divided the appointment into 3 categories. The president or the political sector appoint 3. The Congress appoint 3. And the judicial branch, was able to appoint 3. This is the typical mainstream. Taiwan is exceptional. Number 1 is more justice, 15. And also the appointment process is very different from the rest of the Asian jurisdiction. That is, the president can appoint all, and then the Congress would approve all. So there will be some sort of partisan politics going on, whether it's a minority government or it's a unitary government, and that matter a lot. So yeah, there are some sort of party, positions on this, but luckily, about 1/3 of the appointee to the Constitutional Court will form the university. So you can see in our Constitutional Court, there were about 5 or 6 at least, scholars. And scholars, regardless who appoint them, they tend to be more neutral, more theoretical and more neutral. So they compromise a little bit to that. But that doesn't mean this is really bad or good. It really depends on the court, which court. And for example, through the process, the justice has been continuously appointed by the same president. But still, people don't think they are KMT or DPP, justices. It really depends on how they act, how they behave, how they perform their duty. But take myself, for example, I used to be the victim of that. I was nominated by the DPP president in 2007, and together with 4 others, I was rejected by the Congress, simply on the basis that you are from this party. Although I was not a party member, but still, you serve in this government. So yeah, there are situations like that. But generally, it's not too bad. It's not too bad because other measures can compromise this, and also the issue of the judicial decisions is open for everybody to issue dissenting opinion, concurring opinion, and so everybody can express their idea in a more rational way. Yeah, not only voting. So, which also compromise a little bit about this. Thank you for your question.
Ryan?
Yeah, right. So, I mean, I think you identified really quite, an important aspect of this topic, which is that it is sometimes looks quite a bit like an empty signifier that can be sort of inserted with content to fit whatever needs the speaker might have. And so this guoti term, even just the number of different uses that it's been put to over 150 years, 200 years, kind of demonstrate that it is quite flexible. And so certainly it can be reappropriated for a lot of different projects, for many different arguments. And, just in this sort of big discourse over Guoti or debate of the first 10 years of the 21st century, you see that as well. So you see people who, like Gao Quanqi, who are trying to sort of argue for this pretty radical shift in the direction of a legalization of the state. They're clinging on to this concept in part because it is different from arguing for liberalization as such, right? It's actually a very conservative concept in terms of, you know, the actual content. It's saying that there's this unchangeable essence of the state, which is not necessarily something that doesn't change at all over time, but it actually, it changes sort of in this kind of zone beyond human time. So it can't be artificially changed, even by legislation, even by individual, you know, action or political movements or whatever. So if there's this Republican Guoti, as Gao argues, then that means that need for a representative legislature has this kind of trans-constitutional, trans-legal significance that's just at this fundamental level. So people can use the concept for these sorts of projects, you know, of really de facto liberalization, even though they're using a very sort of conservative lexicon and rhetoric to try and bring that about. But I think you do see that it is much more convenient still for kind of the powers that be to look at the concept and to say there's this unchanging essence of the state, and that means that we're going to deflect people's attempts to change the state in any direction in terms of those fundamental characteristics of party leadership, and maybe more depending on different interpretations of the concept. So I wouldn't say that it's empty as a, you know, in terms of the conceptual content. I think there is a reason why, you know, in the 19th century, you had these Imperial German public law scholars talking about the state form, the Staatsform, and then you had the Imperial Japanese scholars doing the same, and you have Chinese public law scholars doing so through today. It's not just because it's solely for justifying the powers that be, but I think it goes to a sort of type of constitutional discourse that is possible within a very tightly regulated and regimented and, you know, at times obviously dangerous environment for public law discourse. So rather than going out and declaring the Constitution is unconstitutional and we need to liberalize and we need to look abroad for specific models from the West, talking in these sorts of terms, you know, these sort of grand historical narratives about the essence of the state, I think it opens up some spaces that would not otherwise be open in the discourse. But yeah, in terms of whether it goes far enough in that direction to sort of detract from the kind of bigger picture that this is essentially a conservative discourse. It's not about, you know, the popular sovereignty or people sort of engaging in some kind of redrafting of the Constitution to reflect their will, that sort of thing. Yeah, I think it perhaps also sort of draws some of the attention away from those alternative types of conversations that people could have instead. So it's certainly a mixed bag, I would say, in terms of the effects of this kind of discourse. But there are certainly reasons why it is appealing in these kinds of contexts.
All right, Son? Son, you're still muted.
Ryan, we also have the concept of quốc thể in Vietnamese, similar to that concept in China. And thank you, Rehan, for this interesting question. And I've not yet finished my conclusion for the paper. Maybe I will address this question in the conclusion. So my answer is this: two things. I don't think Professor Huang tried to convince the government and try to convince the people that this constitution is unconstitutional. I don't think, and this is why I don't think scholars are convinced by his argument. The thing, I think maybe I should do some empirical work, but I believe that the intention is that he tried to create more problems, problematize the Constitution, and to raise the popular awareness about the problems internal to the constitutions. This is the way to make the problems more serious. When you argue that you have this one, you make this constitution is unconstitutional, you make the problems more serious. And that's still a fundamental and remaining problems in Vietnam. Political party, human rights, and land ownership still remain a fundamental questions in Vietnam now. And that problem that he may want to make sure with the public that these are our problems. And we have not yet resolved the problem with the new constitution. And we have to keep that problems in the future. And this is, I think, the intention of his article. Another point is that for comparative and international law scholars, the lesson is that we can consider how comparative scholarship and international laws are used to irritate constitutional discourse in a domestic levels. How domestic scholars use comparative scholarship, international laws to create more tensions, controversial debates in domestic national level. I will include that in my conclusion for the paper. Thank you.
Thank you. So we have two questions. One I'm going to read out, and then one will be asked directly by the person. So the first question that I will read out is for Professor Ye. The question is, in the process of discussing unconstitutional constitutional amendments, is there any element of transplantation? Have the judges discussed the issue comparatively, or is it based only on the Taiwanese context?
Yes, of course. The judicial discourse has been in Taiwan has been very sort of comparative. They always look to the jurisdictions and to see the precedents and the context for that. But primarily for this is a choice of the strategy, and they of course know some theoretical basis from Germany, for example, about whether there is a limit to the constitutional revision, and in abstract, from theoretical point of view, they did get access to that, and also they get access to other jurisdictions. But by the end of the day, they need to phrase their own judicial, ruling and reasoning by themselves. And I was very struck by this comparison, and particularly this panel. As you see, from the very beginning, I mentioned that Taiwan has to go through a process of total unavailability, political unavailability. So that means these three jurisdictions are not that unrelated. It's related. But what I'm going to say is that the issue in context may be a double-edged sword. You see, in some country, constitutional revision is something that we need in order to move on. In some country, constitutional revision may be a threat to the general public. Let's say, for example, in Japan, most of the liberal constitutional scholars has been watching very carefully how the political sector is going to revise the constitution. And they are kind of drawing back by saying, don't revise this Article 9 so easily, despite the political imperative to do something along the line. Whereas in some country, constitutional revision is part of the political reform. They need to revise the constitution in order to move on. In some jurisdictions, it's almost impossible even to talk about constitution. So the issue about unconstitutional constitutional amendment is, I agree with what what Bui was saying about referring to Professor Huang, it's not only about a judicial strategy or judicial reasoning. Actually, it could be a part of the political process, discourse. By the end of the day, to revise the Constitution actually should be also in the hands of the general public, not strong men, not political parties, not the court. So I would say this reflects quite rich contextual variations to form our general thesis about unconstitutional constitutional amendment. That's what I have in mind right now.
Thank you very much. Dr. Hock?
Thank you, Stuart, and thanks to all, particularly the presenters. It was wonderful to listen to you all people. Excellent presentations. My question is to Sun, and it's with regard to the idea of unconstitutional constitution, not unconstitutional constitution amendment. I think the sub-idea within that idea, sub-idea of the conflict between two provisions of the Constitution is kind of problematic or intriguing, you might say. Say, for example, Professor, with reference to Professor Huang, you said that he argued at least 2 or 3 constitutional provisions unconstitutional, to be unconstitutional for being incompatible with another provision. So this is problematic because when a constitution has 2 or 3 provisions and they are internally conflicting, so the usual interpretation that would come up is to harmonize the provisions, because the framers of the constitution kept those conflicting or diverse provisions in the constitutions for the first place. We have a clear judicial decision from the Canadian Supreme Court regarding this. I'm not going to do that. We also have 2 other decisions from Bangladesh, and one is from Hong Kong. So with regard to the Hong Kong final court, the decision is about the membership of parliament, but this observation came in passing. But let me go to Bangladesh court. This is also very interesting. In one of the cases, we have a provision in the Constitution of Bangladesh that reserves some 50 parliamentary seats for women. Now it's 50, but it started with 10 in the original constitution in 1972. So the government or the ruling party kept increasing the number from 10 to 15, 30, 35, and 45, and finally 50. So many years ago, 3 petitions were filed to challenge reserved women's seats on the argument that this policy of reservation of parliamentary seats violates another original constitutional provision of equality. So no discrimination against men and women. Anyway, so the court said that the amendment is okay. The challenge came when the number of the reserved seats was increased. So the amendment is okay. This is constitutional, despite the other provisions. Okay, the court did not clearly say that it is compatible with the concept of equality. Anyway, so what would be your thought on whether this is a problematic idea to say that one original provision of the Constitution is unconstitutional because another original provision says something else? Thank you.
Yeah, thank you for your question. And whether that can be considered problematic or not, it really depends on the context and the intention of the discourse, the people. Yeah, maybe some in different contexts. In your case, maybe they try to convince that this is really unconstitutional. But I don't think that we have a single answer for that. All the debate on unconstitutional constitution is just to create the problems. Actually, this really depend. But in Vietnam, it's really the intention that they create more. It make the problems more serious. It make the problems more serious. And I think that is I try to focus more on positivist argument rather than normative argument. One of the following positivist argument is that nearly, like Professor Gary Jacobson argues, every constitution is disharmonic. So every constitution has some internal provisions that they may be contradictory together or internally ambiguous. So the thing is that constitutional disharmony creates for the discourse. This can be the discourse for practice, like for example in your case or in another case. But in other case, the discourse can be focused on creating more problems, make the problems more serious, to emphasize that the problem is more serious. But in the end of the day, all of this discourse can be discussed under the idea of constitutional disharmony. But disharmony is good. Normatively, constitutional disharmony is good. This creates the space for dynamic. If the constitution is totally like harmony, so there's no space for you to discuss, to debate. So the good thing about Vietnamese constitution is that there's a very disharmonic constitution. And I'm quite, normatively speaking, I'm quite confident that that constitution is good for creating more the space for dynamic, constitutional dynamics in institutional reform in the socialist state of Vietnam. Thank you.
All right, thank you very much.